This is Attorney Mike Grevin coming to you from Chicago as usual, and today I've got a special treat for you. A commenter sent me a link to a video that is just so deliciously awful. I had to do it. Get ready. We are going to SovSit University. Let's do it. Well, this is fun. I get it in the comments all the time. Where do the sovereign citizens get these ideas? And I've been told and heard and believe that it's out there on the internet. But one of the commenters sent it right to me, and I can't find the comment. Thank you. You know who you are. I responded to you. But this video is so incredibly stupid that if you tried to watch it without the assistance of counsel, you'd probably lose at least 10 IQ points. Don't worry, I've got you covered. That's why I'm here. Let's do this thing.
Welcome, this is TJ from urlaw.org. Today we're going to talk about winning court processes, and really what we think is one of the simplest winning court processes.
Well, here we go already. We've got TJ, probably a fake name because who would want to be associated with this nonsense that follows? Talking about winning court processes. Right there, I can just tell you just the semantics of it. No attorney talks like this. Nobody who actually has ever prevailed in court talks like this. They don't talk in terms of winning court processes. They talk about, proceeding with their case. So you just know it's complete nonsense, and it sure is.
If you've got someone coming after you, an agency, a lawsuit, that sort of thing, really an undamaged party, a non-victim party type of situation happening.
I'm sorry, but the stupid is thick here. I'm going to have to interject a fair amount on this one. But he kicks it off with if you're being pursued by an undamaged party. If you're being pursued by an undamaged party, then just win. Then you have the merits of the case. There's no victim or the party isn't damaged. Whoever's coming after you thinks they're damaged. If the state's coming after you, they think you've committed a crime. If someone's suing you because you hit them with a car or breached a contract, they think that they're wronged. There is no such thing as an undamaged party that's pursuing you, at least in their mind.
You might want to pay particularly close attention because a lot of people have been seeking remedies in the sovereign and patriot movement for years, and they really keep missing the boat by making it more complicated than it really is. I hope.
No, they're not making it more complicated than it is. They're missing the boat by listening to scam artists like you give them horrible, horrible advice, just like you're about to do.
That in this short video I can get you a really good concept of what seems to be working, why it's working, how it's based in equity, which is what we really want. Yet so many people are way off in left field trying to get those things and don't really understand why they're not getting it. We're not about sovereign or patriot movements. We're not about all capital letter names or UCC1s or, glowing in the dark, floating on the cloud theories. We're just trying to stick with what works and what's actually going on in the court.
This is just so rich. He tries to garner some credibility by saying, we're not crazy like the other sovereign citizens. Though he can't go all the way because he knows his audience is sovereign citizens, so he can't completely go there. But he's trying to pose as the voice of reason and saying he's not, suggesting things where they're floating on clouds or something. What he's suggesting is every bit as dumb.
See, so many of us think we have to prove something when we go in. Prove who we are. Prove our status. Prove our standing. Your standing certainly has to be proved. You have to be a party of an interest in what's going on. But you don't have to prove your status. You already have it. You're one of the people. And if these people are committing some sort of theft or fraud against you, you need to be the one to bring that up. And that's a winning strategy for winning. So we're going to talk about requiring the right of subrogation and not consenting. Remember that urlaw.org is a private member association. We do not give legal advice. We're just discussing principles and studies that we've all joined together and learned together from.
Well, let's get this right. They certainly aren't attorneys, and he's trying to claim he doesn't give legal advice. Exactly what he's attempting to do. They should probably be arrested for this. They are attempting to practice law without a license, and they know nothing about it, and their advice is horrible, and it's just based on pure fantasy.
If you want to find out more about urlaw.org, go to that website and find out about the free membership as well as the premium membership, which offers quite a few more features.
Oh boy, there you have it. This really is a scam. I mean, based upon the free material that we are seeing in this video, these people have zero business charging anybody for information that they think they have, because whatever they think they know is wrong.
So what is this big legal remedy? Well, first of all, subject matter jurisdiction is absolutely the one thing I think everybody should be focused on. Not so much, I'm not the name, and I'm not crushing the bar, and I'm not doing all these things. Yes, we've discussed those things, and they might be factors, but they're not going to be what wins your case. So we want to focus on something that will win most types of cases: child support, lawsuits, credit cards, mortgages, tax issues, criminal matters where there's not a true victim or somebody been harmed financially or physically, or traffic matters.
The ideas expressed in this video will win exactly zero of those.
And so we want to go in there and find out what's really going on. So subrogation is a very important concept to understand, as all court cases are actually commercial transactions, even if it's criminal. And they make a claim to your securities to settle the charges or the claims.
I'm going to let Frankie handle this one. Frankie is officially skeptical.
And they do so because you failed to do so. So this is the art. When the prosecutor comes in, he's bringing in a bond. Now that bond is created in your name.
No, he's not. The prosecutor's not bringing in any bond. I've been a prosecutor. There's no such thing. They set bond so that someone can leave, and that bond is a surety so that they will return to court. Everything else he's saying here is complete and utter garbage.
But you failed to make a claim to it. And that bond can be used to set off and settle the claims or the charges or the bill. I think it might even work in a bankruptcy court. I don't know. We'll have to see if some members try it.
I think it'll work in a bankruptcy court. No, dummy, it won't work in a bankruptcy court. We'll just have to see if some members try it. Oh, yeah, you guys try it. Please, if there's anybody contemplating this, and I doubt it on my channel, but if I do reach someone who is actually contemplating doing any of this, don't do it. It is a horrible idea. You will lose, and you will be embarrassed, and it will cost you a lot of money. If you persist and you must do it, I only ask that you take a video of it and send it to me so I can make fun of it.
But imagine being able to set off and settle every case peacefully and get them to do it for you without having to play any special games, be an expert in trusts or equity, spend years studying it. Just one simple concept. So let's talk about the definition of subrogation. And we have the lawdictionary.org/subrogation as one definition up here. The second one I like better, but this one will get you started. The substitution of one thing for another, or of one person into the place of another with respect to rights, claims, and securities. When the prosecutor comes in, he comes in with a bond. You fail to substitute your place in as the beneficiary and creator of that security and use it to set off and settle the case. That's basically what we do by an error when we go in there and enter a plea or just take a lawyer and don't open our mouth. We don't want to do that. So subrogation denotes the putting a third person who has paid a debt in the place of the creditor to whom he has paid it, so as he may exercise against the debtor all subrogation and substantial rights, which the creditor, if unpaid, might have done. So in other words, you're brought in, the name, this is where the all caps name might come in. You don't have to play this game though, but that's the debtor. And you, are the man, are the surety for it.
No, they don't understand. Subrogation, I'll give you a real-world example of subrogation. If you get in a car accident, your insurance company pays to have your car fixed, and let's say they pay $5,000. They might seek reimbursement from the person who hit you and caused the damage. They're stepping into your shoes. That is a subrogation action that really happens in real life. They are trying to use this concept just to confuse their audience, which obviously isn't very bright, and they're using a word like subrogation, which isn't common, so they think it's magical. But in order to buy this nonsense that he's trying to create right now, you have to believe that one person is two different entities, and that's just simply not the case. It's a matter of law. You're one person. If you bring this up, you will lose and get mocked and look silly. That's it.
You need to come in and say, wait a minute, no, I'm the creator of this. I have the equity here. And so the equity by which a person who is secondarily liable for the debt and has paid it is put in the place of the creditor. Now, people run around out here saying, I'm the creditor, I'm the creditor. And all I'm saying is with this one move, you put yourself in that position. You don't need a bunch of UCC-1s and papers filed. So this entitles you to make use of all the securities and remedies possessed by the creditor. The creditor comes in, first of all, it's the prosecutor or the plaintiff at the moment, but once you make your claim, because they created it, because of your existence, you're now the creditor. And that's all you need to be a creditor. You don't have to go run around with a bunch of papers and proving anything. So in order to force the right of exoneration against the principal debtor or contribution against others who are liable in the same rank as himself. Let's look at the second definition. I think this clears it up quite a bit. Remembering, they're bringing a bond in, they wrote it on your name, you're the creditor. Your existence gave the credit existence. Okay? Just like when you sign an insurance policy, you create a credit instrument. Or a mortgage, you created a credit instrument. All right? The court is the place where all this happens. And you need the court to exercise it and take care of it for you. So let's look at this other definition of subrogation from legal-dictionary.thefreedictionary.com/subrogation. I like this definition because it really does actually spell it right out for you. Remembering, if you've studied equity, which is a very advanced thing that a lot of people study out there, I've seen people give classes on it that they seem to take years to explain it to you. But in reality, it's just done with one simple thing. There's a bond there. We want to make our claim to it. And if we don't make the claim, then we're in dishonor, and they literally steal the bond and go make money with it.
It just gets dumber and dumber. He does not understand anything, nor does he intend to. This is clearly just a scam to get people to ask for their premium content, and it's just taking advantage of the unwary. But he's trying to talk about equity like it's some magical thing. It isn't. There's division of law and equity. I can explain this real quickly for the purposes of this conversation. Yes, I've taken things. I've given long lectures on it. One can go on and on about the split between law and equity. But the short version of it is, the remedies are money. And equity, you're seeking injunctive relief. So I'll give you a couple examples. If you sue somebody because they breached a contract and you say they owe them $50,000, well, then you're suing for $50,000. If you bring an action to foreclose on a home, you're not necessarily that there will usually be a law component to that too, but that will usually be brought in an equitable court, because what you're trying to do is get somebody to give the home back to you. You're looking for specific performance, or what's called injunctive relief. So if you're looking for the court to order something specific, or marriage would be a good example. If you're looking for a dissolution of marriage, you're looking for a decree that you are now divorced. It does have some financial implications, but that is more of an equitable thing where the court is granting that. None of that has anything to do with the complete gibberish and nonsense that he is talking about. None.
Don't do that. At least that's the theory of how this works behind the scenes. And we've seen plenty of evidence of it, which is why they seem to respond. So, the subrogation of one person in the place of another with reference to a lawful claim, demand, or right, so that he or she who is substituted succeeds to the rights of the other in relation to the debt or claim, which is the charge or the bill of whatever the case is, and that, even if it's criminal, and its rights, remedies, and securities. So, let's say that again. He or she who is substituted succeeds to the rights of the other in relation to the debt or claim and his rights, remedies, or securities. So you're substituting yourself, and you're telling them, I am the claimant here, I want you to substitute me in as the right to the securities to exercise them. That's all you're really doing. And then that sets off the charges.
This is all so incredibly stupid. We're dumber for having heard it, but I think I can paraphrase this a little bit better than what he did. What he's saying is, you just announced that I don't owe you money, you owe me money. That is basically what he's trying to say. There's no basis for any of this stuff. This presumption that there's a bond and everybody has it and there's some magical account somewhere. All nonsense, all fantasy. None of it based in reality. There's no law. There's no citation for any of this stuff. It's just absolute craziness, and it will never work.
There are two types of subrogation, legal and conventional. Legal subrogation arises by operation of law, whereas conventional subrogation is a result of a contract. Now, people have argued, oh, these are admiralty courts and they got gold fringes around the flag and blah, 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 blah. Throw all that out. Yeah, it might be true, but it's not relevant to winning your case. So let's focus on what matters.
I just love it. He sells out all the admiralty law arguments, which are wrong and stupid, but he's trying to do that to buy credibility for the nonsense that he's putting out right now. And from a scam perspective, it's probably an effective thing. These people have probably tried admiralty law arguments; they always lose. And then he says, "No, it's not like that. This is better."
So what you're doing is, you go in these courts and they want to get you into a contract. They want you to waive and give up and volunteer into their system and walk away from your securities. That's what they want you to do. So if that's all you need to think about, you don't need to worry about whether you trip up and say your name or you have a driver's license or a U.S. citizen. Just throw all that out for a minute and just look at this.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought.
This is what's happening at the moment. All right? You have a right to come in here and make this claim. The purpose of subrogation is to compel the ultimate payment of a debt by the party who, in equity and good conscience, should pay it. The subrogation is an equitable device used to avoid injustice.
It's just so unbelievable. First of all, they start with this fantasy that there's some equity that you have somewhere in some magical bank account. There isn't. It's complete nonsense. Then he says the purpose of subrogation is so that the right person pays the debt. Well, I can see that's actually true, and he's getting it from definition. But that does make some sense. But what is it? What are we trying to get out of here? We're trying to get out of a credit card that we made purchases with. We're trying to get out of child support. We're trying to get out of a crime we committed. Who should be paying for that? Who should be paying for that? The Sov Sit, who's trying to get out of something that they owe.
Now, this is where we talk about equity. People have taught about equity. I'm going to give you the simplest way to ever look at it. You want equity, right? If you brought something of value in, or they created something of value in your name, the equitable thing to do would be to allow you to say, hey, that's mine. Use it to pay the bill. That's equitable, right? So that's what equity is. So you're saying, I want you to exercise my right of subrogation and use your instruments to settle the debt. And for someone to come, by the way, when you come to court and you want to sue someone, sometimes the judge will ask you for a bond. Why? Because you have to bring equity in case you do damage to them.
No judge will ask you for a bond if you're bringing an action in a civil context. At least it hasn't happened to me, but what do I know? Civil litigator of 25 years.
Well, prosecutors and plaintiffs typically need to bring a bond as well. Now, they may or may not do it, but that's what they're supposed to do because they may damage you. Well, now you're saying, hey, I want to use that bond to set off the debt because you created it in my name. Does that make sense? So, legal subrogation takes place as a matter of equity, with or without an agreement. So in other words, you just walk in there, you say, I want my equity. The right of legal subrogation can be either modified or extinguished through a contractual agreement. So you could waive this. It cannot be used to displace a contract agreed upon by the parties. Conventional subrogation arises when one individual satisfies the debt of another as a result of contractual agreement that provides that any claims or liens that exist as security for the debt, that's the charge, the bill, whatever the claim is in the court, to be kept alive for the benefit of the party who pays the debt. So you're saying, take the security that you brought into this bond, pay the debt with that. That settles the charges. It is necessary that the agreement be supported by consideration. However, it does not have to be in writing and can be either expressed or implied. The consideration is the bond that was brought in your name. You're just utilizing it instead of walking away from it. and letting them profit from it while you go to jail for not doing what you should have honorably done, which is issue the credit. Well, that's what you're doing, is you're issuing the credit. It was issued before you got there. You just need to tell them how to exercise it. The facts of each case determine the issue of whether or not subrogation is applicable. In general, the remedy is broad enough to include every instance in which one party, who is not a mere volunteer, pays a debt for which a second party is primarily liable, and which in equity and good conscience should have been discharged by the second party. So in other words, the prosecutor brought this charge in. It probably has no standing in law, so you should have him discharge it. But you don't direct him to do it. This is the way we're not trained to do it. They tell you to just get a lawyer and shut up. No, you should walk in there and make this happen.
Oh, that is so good. Just walk in there and make this happen. You gotta be kidding me.
So subrogation is a highly favored remedy that the courts are inclined to extend and apply liberally. Well, actually, they have to. As far as what we've been able to find, they really have to. The ordinary equity maxims are applicable to subrogation, which is not permitted when there is an adequate legal remedy. Now, all these guys are running around saying there's no more courts of equity, or there's no more, throw all that stuff out of your brain. Here it is. It's telling you the ordinary equity maxims are applicable to subrogation, which is not permitted when there's an adequate legal remedy. Okay? The plaintiff must come into the court with clean hands, and the person who seeks equity must do equity. So I seek equity, so I must implement equity. That's what it's saying. So if you don't do it, you're in dishonor and you go to jail, or you lose.
And if you do it, you're going to be convicted and probably get some contempt thrown on top of it.
So you're fighting the wrong issues when you go to court. The remedy is not available when there are equal or superior equities in other individuals who are in opposition to the party seeking subrogation. Trust me, nobody has a higher claim to your equity than you, because you created it.
I'm going to come right out with it and say, I don't trust you.
The remedy is denied when the person seeking subrogation has interfered with the rights of others, committed fraud, or has been negligent. This is where it's very important. This will probably not work if you've defrauded somebody, you've harmed them, you've stolen from them, you've killed them, you've raped them, you've robbed from them. In other words, you've done a harm. You've been negligent.
It's so good. This won't work in any circumstance where the other party has a good case against you. Okay, if you haven't done any of those things, if you haven't harmed somebody in some way, or don't owe them money, or haven't committed a crime, well, then you can win on the merits. And that's what I suggest you try to do.
This is when equity gets thrown out the window. This is why people say you have to have a damaged party for the court to go forward. Well, that's technically true, but they do it anyway, don't they? Because you don't come in and actually turn the court into the proper transaction, which is this, subrogation. People are missing it. The right to subrogation accrues upon payment of debt. The subrogee is generally entitled to all creditors' rights, privileges, priorities, remedies, and judgments. By the way, you're the subrogee when you ask. If you don't ask, you're not. So again, the subrogee is generally entitled to all the creditors' rights, privileges, priorities, remedies, and judgments, and is subject only to whatever limitations and conditions were binding on the creditor. He does not, however, have any more extensive rights than the creditor. So, you can't go do harm and hurt the other guy, but he brought this thing in, the prosecutor, the plaintiff. You need to take it, make your claim to it. You become the creditor. This flips the case around. It kind of makes you the plaintiff. And now you have the creditor's rights, privileges, priorities, and remedies, and judgments. Did you have to do anything about filing UCC-1s or changing your name or taking your birth certificate and having it authenticated? No, none of that matters. You're there. You already have your status. You just need to act like a sovereign, if that's what you want to call yourself.
Well, here we go. I finally agree with him about something. None of that matters. All the filings and all the other soft-sit nonsense, yes, those are all horrible ideas, as is the idea that you're putting forward right now. It just isn't going to work.
And forget about all that other stuff that they're going to get into. They're going to try to talk about everything but this. And they will try to avoid this issue. This is at least what we've seen so far, and it makes sense that they would. Because this is their money machine. And we're not trying to take anything from them. We're just trying to take what's ours and put it to our use. That's all this is. If you didn't get this, go back and watch this again. We have a full description of this and these written instructions, as well as several other questions you can ask before the court. In the premium member area, if you're a premium member of urlaw.org, free members will get part of this. They won't get the full amount. The full information is in the premium area. So here's our comment. This applies directly to any court charge you have the highest equitable claim to matters involving your name, estate, which the court has made. Let me fix that typo there. Involving your name, which is an estate which the court has made an account of, or of securities, a security out of. Therefore, requiring the plaintiff or prosecutor to certify your right to subrogation when you ask for it. Just ask for that. Don't make it any more complicated than this. Keep this simple. This turns the tables and makes you really the plaintiff and orders them to settle the accounts. So you should order them to just simply ask. So this has been tested with live in-court situations and is quite effective. If you listen to one of the recent audios, I think it was from the week of November 15th, 2017, we have one person on there who walked in and simply asked this one question. I demand my right to subrogation. And we're not moving on from that point until we get that resolved. He stayed on that. They try to get him off subject, but he simply says, well, but before we can proceed, I need the prosecutor to certify my right to subrogation. Just you make them acknowledge it. You know you have a right to it. And once they certify it, it's yours. Equity is done. And then you say, now I'd like you to sell off and settle the account.
Yeah, I'm calling BS on that. If that happened, show us a clip of it. Show it to us right now. You've got that in your possession. Show us your big win in court. You will get laughed at for bringing up this sort of silliness in an actual courtroom. It makes no sense. You're not citing any law. There is no law. And none of this makes any sense. And you didn't win. And if you did, you'd be showing it to us.
And that's probably the judge's job as trustee there to sit there and handle the accounting for the case, whatever it is. So you got to get out of the mindset that it's this written statute that they came up with. It really isn't. Unless there's a harmed party, this is all that's going on. So you could even write a letter. I don't know if this would work, but somebody you could try it.
Oh, and the stupid just continues. He's had it up there for a while, but you can write a private letter to the judge. Yeah, that's what's called an ex parte communication. You get in trouble for that. You can't do that. Any communication with the judge overseeing it has to be in the presence of opposing counsel as well. I just love this, and even he knows. He's like, well, you could try that. I don't know if it'll work. Yeah, you don't know if it'll work. You're not an attorney, and you're clueless.
Will the plaintiff or prosecutor certify my right of subrogation? And send a copy, of course, to the prosecutor or plaintiff, and a copy to the court. Always copy all parties if you're not sure. That's the rule of thumb. I don't know, but I just assume you should notify people.
It's too good. I don't know. It's a rule of thumb. It's not the rule of thumb. It's the rule. It's the law. You can't have communication before the judge without including opposing counsel in a pending matter that's in litigation. That's the way it is. I do know. I do know how this works. You can't do this, and the judge isn't deciding cases on the letters that are sent. There are ways to do these things. We have motions and discovery process. Depends on the particular type of matter we have going on. But I love how he offers a bad idea, but then tries to just slide out of a little bit by saying, "Well, I don't know." Yeah, clearly you don't.
If you already have an attorney, maybe show him what you plan to send to the judge. He probably will try to tell you you're crazy not to do it. He'll probably run away from or discourage you, because it kind of exposes the game that's keeping the whole system running on full profit for them. The legal industry is a machine. It's an industry. But you want to send this letter privately to the judge in chambers. Again, a copy to your attorney or to the prosecutor and plaintiff. Give everybody a notice. But to sign it as living soul and ask the question, I want somebody to certify my right to this. And if they try to deny it, well, then they're really in dishonor. They're really there's a serious claim you could make at that point.
If you send a letter, especially if you sign it as living soul, or use the phrase notice of dishonor, or someone being in dishonor in a legal proceeding, you will lose all credibility, and the judge will have a hard time keeping a straight face. You will lose any issue that you are discussing, and you will get nowhere.
But just get to that point and see how it goes. Don't let them stop you from exercising your right of subrogation. But you must demand it to get it. If you get off on talking about anything else, traffic, this, that, statute, listen, there are great arguments for those things. There's great arguments for subject matter jurisdiction on traffic, tax, property taxes, whatever. There's plenty of that. We have plenty of that material on the website. But let's just do the first things first. Let's get into the court the right way. And this kind of throws out some of the previous theories because we really have narrowed it down to a simple thing to do. So anything else has been trying going in, you might want to try this first. Don't play the name game. Don't have to say you're a sovereign man on the land standing on your tippy toes or walking on the clouds. Just stick to go in there, give them your name, and ask the question. They won't hit you for non-appearance if you give your name, right? But just simply stick to the subject what you're there to do. Tell them, I'm only here to take care of this. That's it. All right? You could get a lot of legal lingo, but you don't really need to. Just stick to the one thing. There are several testimonials on a 4-step script and stories in the premium member area developing, and if you're on our premium member calls, you'll hear more of these discussions in the upcoming calls. So until then, thank you, and please visit urlaw.org.
Well, there you have it. I actually ended up having fun doing that. I know this video is a little bit long, but this is sort of an answer to a month's worth of comments asking me to get serious and in-depth. I didn't really dig into any law. This was all off the top of my head because they don't cite any law. They go to the dictionary and they read a definition of subrogation, which is okay as far as it goes, but it isn't applicable to the scenario. They just have no underlying basis. The problem is when people want me to counter these things is that they're so far out in left field. It starts with the premise that there's some magical bond and account for you which doesn't exist and that sort of thing. There's no there. There's no good argument. It's just fantasy. That's what the problem is. But if you want to see it in excruciating detail, there it is. For those of you who want to nerd out and really get into it, this was so horrifically bad. I just had to respond to it, and I actually did have fun with it. So there it is. I'll put it up, and I can, I guess, point people to it in the comments when they want something more specific about why they're wrong. But I don't know if there's any interest in it. Maybe I'll do another one. But that's where they're at. Their arguments are just plain bad, and there's no law to go to because they haven't even reached. They haven't made a good enough argument that it needs to be refuted as a matter of law. They're just wrong. They're just citing fantasy and nonsense. Here at Law Talk, we do a lot of videos answering common legal questions. We also do reviews of law in the movies and then on TV. We also share some of our more interesting cases. We're always putting out new videos. So if you like that, please hit like, subscribe, and ring the bell.